Hello everyone and welcome back to Oba's Trending Gist. If you've been following the saga of Mazi Nnamdi Kanu, you know the situation has just gotten critical following his conviction by the trial court. The internet is buzzing with rumors, emotions and political statements. But today, we are pushing emotions aside to look at the cold hand legal reality. Following the judgment by the trial court, there has been a lot of noise, a lot of tears and a lot of anger online, but on this channel, we deal with facts. The reality on the ground has changed. Nnamdi Kanu is no longer a suspect awaiting trial. In the eyes of the law, he is now a convict. He has been moved from the DSS detention facility and is reportedly being held in a correctional center with many sources pointing to Sokoto prison. This shift from accused to convict changes the rule of engagement entirely. He is no longer presumed innocent. So, the big question everyone is asking is this the end of the road? The answer is no. But the road ahead is narrow. According to top legal experts, the senior advocates, there are only two options available to him right now. In this video, we are going to do a deep dive analysis of formidable appeal and the presidential pardon. We will look at the constitution, the risk of him representing himself, and whether being in Sokoto affect his chances. Grab your popcorn, sit tight, and let's analyze this critically. So let's start with the first and the most immediate legal option, the appeal. Now, this isn't just about filing a paper saying, I disagree. This is a constitutional right available to every convicted person. But legal analysts are warning that this is a critical stage where mistakes cannot be made. The law allows for a period of 90 days to file a notice of appeal. That sounds like a lot of time, but for a case of this magnitude, this is very short. Why? Because the work required is massive. Once the notice of appeal is filed, the legal team cannot just sit back. They have to approach the Registrar of Justice Omotosho's court, the trial court. They have to pay specific fees required by law. They have to compile the records of appeal. We are going to talk about compiling the entire history of the trial, every argument, every ruling, every piece of evidence into bound volumes. In a case like this, we could be looking at 15 to 25 volumes of records. This must be transmitted from the High Court to the Court of Appeal. The goal here is to puncture the judgment. The lawyers have to raise a grounds of appeal. They have to look at the judgment and say, my lord, the trial judge made a mistake here, here and here. If they succeed in convincing the appellate judges that the trial court was in error, the conviction can be set aside and he can regain his freedom. But, and this is a very big but, there's a huge risk involved here which I need to discuss next. So during the trial, we saw moments where Nnamdi Kanu chose to defend himself. The law allows this. However, legal experts are sounding a loud alarm. He cannot afford to represent himself at the Court of Appeal. Why? Because the stakes are too high. At the trial stage, you are fighting facts. At the appeal stage, you are fighting technicalities of the law. You are fighting judicial precedents. As one analyst put it, there is no room for gambling or testing the microphone at this stage. Attempting to pursue an appeal of this magnitude by himself will be a legal suicide mission. It will be like digging a pit for yourself and jumping inside. The lawyers on the other side, the government's lawyer, are trained experts to match them. Nnamdi Kanu needs to engage the absolute best legal hand in Nigeria. We are talking about seasoned senior advocates of Nigeria, that is SANS, who understand the nuances of appellate laws. It will be too much of a legal risk for him to take this up personally. The emotional aspect of the case must be separated from the technical aspect. So to all the supporters watching, the message from the legal community is clear. Let the professional handle the appeal. Now, let's look at the second option, which is more political but deeply rooted in law, the presidential pardon. This is legally sound. As the prerogative of mercy under the Nigerian legal system, this power lies solely with the president because Mazi Nnamdi Kanu was charged under federal acts of the National Assembly. No governor can grant this pardon. It must be the president. But let's look at the section 175 of the Constitution because it gives the president incredible flexibility. It is not just a yes or no situation. According to section 175, the president can grant a full pardon. This wipes the slate clean. It's a complete acquittal. Grant a conditional pardon. He can say you are free, but you cannot leave the country, or you are free, but you must report to the police quickly. Grant a respite. This puts a pause on the execution of the punishment for an indefinite specific period. For example, allowing him to travel for medical care for 6 months. But here is the most interesting part. Section 175, subsection 1c. This allows the president to substitute a less severe form of punishment. Remember, Mazi Nnamdi Kanu has sentences ranging from life imprisonment to 20 years to 5 years for the radio transmitter charges. The president has the power to look at the life sentence and legally turn it into 5 years. He can look at the 20 years and turn it into time served, meaning since he has been in detention for years, he can go home today. However, the president doesn't act alone. He must consult with the Council of States. This body includes presidents like OBJ Jonathan, the CJN and all state governors. The process also involved the Attorney General of the Federation, AGF, and the Committee on Prerogative of Mercy. They will review reports from security agencies. They have to ask, is it safe to release him? What is the security report? So, while pardon is an option, it is a product of high-level consultation and politics. Think of appeal as a right and a pardon as a privilege. You do not throw away your rights while waiting for a privilege. Nothing stops his legal team from filing the formidable appeal tomorrow morning, while simultaneously political leaders and traditional rulers lobby the president for a pardon. If the pardon comes through, great, the appeal is withdrawn and the case ends. But if the pardon doesn't come, you haven't lost your 90 days window to appeal. They must run side by side. Finally, let's address the rumor about his location. Sources say he is in Sokoto prison. Yes, we all know that. Does this hurt his appeal? Legally, no. When it comes to court of appeal, the physical presence of the convict is not required. It is not like the trial court where he stands in the dock. Appeals are fought on paper, through briefs and record. His lawyers will do the arguing in court while he remains in custody. Even the pardon process doesn't require him physically present at the villa. However, if he insists on being present in the court, the state is obligated to provide the logistics and security to bring him from Sokoto or wherever he is to the court. But generally, his location does not stop the legal wheel from turning. So, in summary, the stakes are incredibly high. The era of presumption of innocence is over. Nnamdi Kanu needs a formidable appeal handled by the best lawyers in the land, and he needs a strong lobby for the presidential pardon under Section 175. Gambling with self-representation now is dangerous, and waiting for a pardon without filing an appeal is equally dangerous. The days ahead will reveal a lot about the strategy of his team and the disposition of the presidency. As always, we will be here to break it down for you. What do you think? Should the focus be on the legal battle or the political pardon? Let me know in the comment section. If you found this analysis useful, please like this video, share it with your friends, and subscribe to Oba's Trending Gist. Turn on the notification bell so you don't miss the next update. I remain your host, Oba. Stay safe, stay informed. Bye for now.